Good evening to all of you. I thank all of you for taking out your time for this webinar. The subject which I'm speaking on today is the impact of COVID-19 on labor law compliances. As you all know, that there has been a nationwide lockdown which has been imposed by the government of India. Starting from 25th March onwards, this lockdown has been extended till 3rd May 2020. Before I deal with the law on this subject matter, let us first know as to what is a lockdown. Now, a lockdown is basically an emergency measure or a condition whereby people are temporarily prevented from entering or leaving a restricted area or building during a threat of danger. Now, the basic legislations which are applicable as far as the labor laws in our country, they basically apply to two categories of employees, namely workmen and non-workmen. Now, most of the labor legislations apply to workmen. The legislations relating to today's subject matter are the Epidemic Diseases Act, the Disaster Management Act. When we come to the provisions of the Epidemic Diseases Act 1897, this was enacted with an objective to prevent the spread of epidemic diseases. Both the central and the state governments have the power to take measures to control this epidemic. Coming to the Disaster Management Act 2005, now this particular act enables the central government to set up a National Disaster Management Authority to effectively manage a disaster. COVID-19 can be classified as a disaster under the provisions of the DMA. Now, under this act, the central government is empowered to lay down policy plans and guidelines so as to ensure a timely and effective response to the disaster. As per this act, all the states are obliged to follow the directions of the National Disaster Management Authority. There is a provision in this act, which is Section 72, which lays down that this act will have an overriding effect to the extent they are inconsistent. Now, you are aware the government of India, as most of them are in the nature of advisories, whereas one such order which has been issued is basically a mandate which has been issued by the Ministry of Home Affairs. Now, as far as this circular dated 20th March 2020, which has been issued by the Ministry of Labor and Employment, this advises employers not to terminate the services of workers or not to effect any wage cuts as far as workers are concerned, and also to protect the interests of casual and contract workers so as to ensure that their services are not terminated by the employers. Now, this also provides that if the place of employment becomes non-operational due to COVID-19, then the employees of such unit will be deemed to be on duty and they would be entitled to wages. We have an order which has been issued by the Ministry of Home Affairs, MHA, under the provisions of DMA Act. Now, the authorities have invoked the special provisions of Section 10 into bracket 2 into bracket L of this Act, whereby the National Executive Committee has the powers to lay down guidelines for certain ministries or departments of the government of India, or even the state government departments, regarding measures to be taken by them in response to any threatening disaster situation or disaster. Now, based on this particular provision, based on this particular provision, that is section 10(2)(L) of the DMA, the authorities have taken out an order dated 29th March 2020, stating that all employers, be it in the industry or in the shops and commercial establishments, shall make payment of wages of their workers at their workplaces on the due date without any deduction for the period their establishments are under closure during the lockdown. Now, this order which has been invoked, this order which has been taken out by the authorities under the DMA Act has a statutory force and is required to be complied with by the employers. Now, basically, if we see the implications arising out of these orders and advisories, now these orders and advisories have been issued by the central government as well as the state governments in the larger interests of employees and workers in view of the need for money as far as meeting their daily need requirements are concerned. Can we now understand as to what are the effects of these advisories and orders? Now, as far as these orders and the advisories are concerned, employees are required to be exempted from attending their duties except in essential services. Employees can be permitted to work from home if the nature of work so permits. Now, all industries and factories, except those dealing with essential goods and services, shall remain closed. It will be obligatory upon the employers not to terminate the services of employees, including contract labor, during the period of lockdown. Companies are obliged to pay full wages and not to reduce wages for all the employees, including casual and contract labor during the lockdown period. Now, while we interpret the provisions of law, and in particular the DMA Act which has been invoked by the authorities, first and foremost, COVID-19 can be termed as a natural calamity. Now, we have the provisions of the Industrial Disputes Act which permit an employer to lay off his employees. Now, in cases of establishments which employ more than 100 workmen and which are Chapter 5B establishments, generally permission is not given by the government. An employer is required to take permission of the government before he either lays off or he retrenches his employees. And such permission is not forthcoming. But as far as COVID-19 is concerned, it can easily be termed as a natural calamity. And for natural calamity, no permission of the government is required under the provisions of Chapter 5B of the Industrial Disputes Act. Now, if that is so, and if the employers decide to lay off the employees by paying 50% wages by way of layoff compensation, then this would amount to breach of the orders of passed by the MHA under the DMA. This is because the order makes it very clear that the employers cannot reduce wages of the employees during the period of lockdown. Now, there is a provision that the provisions of this act, the DMA, they have precedence over all legislations. So this would include the Industrial Disputes Act, the standing orders, and all other labor laws on account of Section 72 of the DMA, notwithstanding any inconsistency or conflict with any other law. Now, posing here for a moment, there are employers who have their standing orders. They have certified standing orders which provide that in cases of any catastrophe or a natural calamity, an employer has a right to shut down his establishment forthwith and not pay wages. But if the employer takes recourse to this provisions of the standing order, then it would still amount to breach of the order dated 29th March 20 passed by the MHA. Both these legislations, the DMA and the EDA, they do not govern the relationship between an employer and an employee. Now, the objective of DMA is to provide for effective management of disasters. Now, while the DMA does not empower the central government to issue directions to private employers to pay full wages during a disaster, as we had gone through the provisions of Section 10(2)(l) of the Act. Now, there is no such power vested with the government to direct employers to pay full wages during this disaster. But however, the directives have been issued with an object of curtailing the spread of the disaster stroke epidemic. Let us also see the consequences. Now, if there is a breach of the provisions of this DMA, then under Section 51B, it could result in imprisonment to an employer up to a period of 1 year. It is therefore clear that the provisions of the order, that is the 29th March 2020, this order will be binding on all the employers. Now, in this regard, I would like to draw your attention to a very recent order which has been passed by the Supreme Court on 31st March 2020. This is in the case of Alok Srivastava versus Union of India. Now, basically, what had happened was that there were these migrants who were basically walking from Delhi to UP and Bihar to their respective homes. And finally, a petition had been filed with a view to ensure that they get the facilities of dwelling, basic amenities relating to water, food, etc. Now, in that context, the Supreme Court had the occasion to refer to this circular of 29th March 2020. Now, this circular of 29th March 2020, which has been referred to by the Supreme Court, this is basically in respect of redressal of grievances of migrant labor. Now, if you go through that circular, now there are 5 such clauses there, wherein clauses 1, 2, 4, and 5 are in fact meant for mitigating the hardships of migrant labor. Now, it is only clause number 3 which is made applicable to all categories of workmen. It applies to not just migrant workmen, but to all workmen, wherein directions have been given by the Supreme Court, the directions have been given by the MHA to ensure that the employer does not reduce wages and that he pays wages to all the workers. Now, what the Supreme Court holds while referring to this order of 29th March 2020, that disobedience to an order which is promulgated by a public servant would amount to punishment under Section 188 of the IPC. An advisory which is in the nature of an order made by a public authority attracts Section 188 of the IPC. We trust and expect that all concerned, that is the state government, the public authorities, and citizens of the country, will faithfully comply with the directives, advisories, and orders issued by the Union of India in its letter and spirit and in the interests of public safety. Now, there have been special leave petitions there are special leave petitions which have been filed in the Supreme Court challenging the validity of this order of the MHA. Now, one such SLP was filed by a company known as Nagrika Exports, who has already withdrawn this petition, but there are petitions filed by an employer known as Ficus Pax Private Limited, as well as Ludhiana Hand Tools Association. Now, these matters had come up for hearing before the Supreme Court and have been adjourned to 11th of May and will come up for hearing on, it is expected that they will come up for hearing on 11th of May. Now, the effect And the effect of this order of the MHA dated 29th March has not been stayed so far by the Supreme Court. Now, let us understand the after effects of lockdown. Now, once the lockdown is lifted, it is certainly going to result in a paradigm shift. There will be several economic measures being resorted to by employers, such as downsizing, there will be retrenchments, there will be layoffs, and this could result in job security amongst the employees. The organizational priorities will certainly shift to cost reduction measures and retention of the existing customers of the companies. There will be drastic pay cuts, deferred increments, and hiring of employees will be freezed. We hear, in fact, of so many companies who have already announced that there are going to be wage cuts in respect of their managerial and senior managerial employees. So there is every possibility that this would happen even after the lockdown is lifted. Now, no doubt there is going to be resistance from the workmen and the labor unions representing the workmen force, and the matters would obviously be contested in courts. There would be litigations, and employers would be required to resist such litigation. While concluding, my recommendations would be that if the outbreak does not abate, then the disruption would continue, and any further extension of the lockdown period would result in employers going through further hardships and even bankruptcy. There is therefore a need on the part of the government to subsidize the wage cost of employers during this lockdown period, if not fully, then at least partly. But till such time, a holistic approach or a balanced view will have to be taken by the employers by ensuring that they do not terminate the services of the employees or disengage any contract labor during this lockdown period. Thank you so much. Thank you.
There are certain employers who have already reduced the salary to an extent of 40%. How does that take place?
Now, as I mentioned, that the trend has started, and the companies are in fact reducing the pay packets of employees employed in the managerial category, managerial, supervisory, and administrative categories. So such employees who are employed in the management cadre, so it has already been announced that the company is effecting what you call reduction as well as wage deferrals. Now, that could happen as far as these categories are concerned, either by consent of the employees, or the employers could notify to the employees that on account of the huge economic crisis being faced by the company on account of this particular event, so therefore the company has no other option but to reduce the pay packets of the employees. And therefore, the companies have attempted to reduce the pay packets of employees in managerial cadre, but reduction of such salaries of employees employed in the workmen cadre during the period of lockdown will not be permissible in law.
Another question is, are wages and salaries considered the same under the Act? If not, then deduction in the salary will also be considered or protected under DMA?
Yes. Now, as far as wages are concerned, now if you see the circular of 29th March 2020, it talks of workers and it talks of wages. So we can certainly take into consideration the definition of wages as defined under the Payment of Wages Act or under the Industrial Disputes Act. So therefore, it would be basically, if we refer to the provisions of Payment of Wages Act, and in particular section 1(6) of the Payment of Wages Act, there is a ceiling of rupees 24,000. So such employees who are drawing wages exceeding rupees 24,000, you could take a position that they are not to be considered for the purposes of this circular.
Okay. One more question. Since DMA doesn't apply to private companies, how can it be made binding on all?
Now, as far as DMA is concerned, now there are certainly very valid grounds in respect of challenging this particular order which has been issued by the Ministry of Home Affairs. So therefore, this DMA Act, in fact, does not even govern the what you call service conditions of employees or workmen. So the objective of this act is basically to prevent or to take steps in respect of disasters. Now, nevertheless, the government has still invoked this particular provision under the DMA and has given this mandate that no employers should reduce wages or should not pay wages to the employees. So in this context, as long as the circular order has been passed by the MHA, it has a statutory force and it is required to be complied with by the employers, even private employers. Non-compliance will result in prosecution. So the only recourse available to the employers is to challenge this order, or in the event the employer is unable to what you call comply with this directive, he is unable to make payment of wages due to financial stringency. And if there is any prosecution which is initiated by the authorities, then the employer will have to challenge that before the High Court.
Bharat, one question. Does it apply to charities and NGOs?
It would apply to industries. It would apply to industries. So therefore, even NGOs and charitable trusts, yes, would be still governed by it.
Okay.
So those people who are employed, who are workers and who are employed in NGOs and charities would also be governed by this order.
Okay. Another question related to this. If you are working from home and subsequently you apply for leave, how is that dealt with?
So if you work from home and it is treated that as if you are on duty. He's performing work, an employee is performing work from home. So it is treated that he's on duty. But if he wants to apply for leave during that period of lockdown, then in that case, he will stop working from home for that particular period when he applies for leave. And if that leave is granted, then he need not work from home for that period of time for which he has applied for leave.
Okay. What is the definition of a workman? Will it be applicable for teachers also?
No, not for teachers, because teachers are not considered to be workmen under the ID Act.
Okay. What is the difference between contract and casual?
Now, as far as contract workmen are concerned, now they are basically employees who are engaged by vendors or third-party agencies. Now, to give you an example, I want to engage certain manpower for executing certain jobs. So for that purpose, I engage a service provider. So I enter into a contract with a service provider, and the service provider brings in his employees for carrying out the job required under the contract. Now, as far as casual workmen are concerned, they are my employees, but I employ them only on a casual basis, maybe on account of absenteeism of permanent workmen. So therefore, if such casual situations arise, I employ them. But as far as contract workmen are concerned, they are employees who are engaged through third-party agencies in my premises, that is the principal employer's premises.
Okay. There's an interesting question. In a private company governed by Shop and Establishment Act, an employee who does not fall in the definition of worker, can the employer ask such employee to go on leave without pay during the time of this lockdown? Is this permissible?
No, answer is no, because leave is ultimately to apply for leave, it lies within the discretion of an employee. Now, an employer cannot mandate an employee to go on leave. But in certain situations, now I'll give you an example. When can an employer require an employee to go on leave? Now, in a situation where I am an essential service, now I am permitted to carry out my duties. I basically take the necessary safeguards. I provide transportation to the employees. I provide personal protective equipments to the employees, and I require them to report for duty. Now, despite that, if the employee does not report for duty, I am entitled not to pay them wages on the principle of no work, no pay. Alternatively, then in such a situation, I can tell an employee that you better avail of leave lying to your credit, otherwise I will not pay you any wages for this period of time. Or it is only in these circumstances I can require an employee to avail of his leave, but not otherwise.
Okay. What is the position of education institutes which are not under the ID Act and therefore not covered in the definition of workmen? Therefore, can the support staff employees be acted upon with any action, such as salary or retrenchment?
If the provisions of, but here the law is very clear. The order which is passed by the authority is very clear. If you see his order, he makes it of the MHA, no employee employed in any industry. Now, why do you say that this educational institution is, this institution is not an industry? Because it says that any employer, be it in the industry or in the shops and commercial establishments. So it basically covers.
Can you hear us, Bharat?
Yes, I can.
Okay. The next question uh, is this order applicable to professionals who charge fees and are working with firms?
No, it would not. Employers in the industry or in shops and commercial establishments. Can you just repeat your question once again?
If you're a professional
Yes.
and it's like a consultant working with a firm, is it applicable to them? Because professionals who just charge fees and are working with either law firms or consultancy firms.
So it may not apply to them.
Okay.
It may not apply to them.
Okay. What about employees who have newly joined?
Now, employees who have newly joined, appointment letters have already been issued to them. They would be entitled, they would be covered by this order, and they would be required to be paid wages during this period of lockdown.
Another very strange question, does this apply to domestic workers?
Yes. Now, as far as domestic employees are concerned, domestic workers are concerned, see, it is always advisable not to take any such acts of termination or reduction of wages during this period. Even if it happens to be a domestic worker, always advisable. See, there are help desks also. Now, what is happening is these persons, employees, they are lodging complaints before these help desk authorities, and they are then in turn, questioning the employers as to how they are terminating the services. In case if they do not take back the employees, then they threaten them of prosecution. So it is always advisable not to do so during this period of lockdown.